Department here today from Suquamish Tribe, John Anderson in the back, Joanne also in the back, and myself. So if you have any questions during the course of the press conference, feel free to take one of us aside and ask the questions. So I want to get started by just regrets that unfortunately Bob Ferguson is ill and is unable to join us. So we're fortunate to have Bill Sherman stepping in for him. But otherwise, we're very excited about today's press conference and about the settlement that we're going to be announcing today. And to make the announcement, I want to turn that over to Leonard Forsman, Chairman of the Suquamish Tribe.
Okay, thank you, Sarah. Welcome everyone to the Suquamish Tribe, government offices, and the Port Madison Indian Reservation. And my name is Leonard Forsman. I'm the chairman of our 7-member tribal council, and my ancestral name is Gui. And we are really appreciative of the people who have come here to announce this settlement with the Navy on an important issue. And as you know, this is home of Chief Seattle and Chief Kitsap, and we've been here on our reservation since 1855, and of course for thousands of years before that in this territory, roughly in the central Puget Sound and the Kitsap Peninsula. And this reservation was established by the Treaty of 1855. Not signed we just had the anniversary of that treaty signing just a few days ago. And in the spirit of that, we've been trying to work with our lawyers and our technical staff and our fishermen on trying to protect Puget Sound and the treaty resources that we were promised would be preserved during those negotiations, and also have an opportunity to harvest those as well as we do today. And as you all are well aware, that the Puget Sound is very fragile and under a lot of pressure. And today's settlement will hopefully be an example of how we can work together to prevent these pressures from mounting and try to preserve this beautiful gift from our Creator for the future generations, and protect the salmon and shellfish and the southern resident killer whales as well. I'd like to welcome the Attorney General's office. We really understand. I know Bob Ferguson well, and I know how committed he is to this issue and his job, and I know that he must be really sick if he's not able to make it here, because I know how Bob likes to come in and join us here in Indian Country. And I'd like to welcome Caitlin Kinn from the Clean Water Attorney for Puget Soundkeeper, Mindy Roberts, Puget Sound Director for the Washington Environmental Council, this one here, and Bill Sherman, Counsel for the State Environmental Protection Unit Chief, who's standing in for Attorney General Ferguson. Appreciate that. This morning, the Suquamish Tribe, State of Washington, Puget Soundkeeper Alliance, and the Washington Environmental Council filed a court settlement with the U.S. Navy concerning the hull scraping of the X-Independence, or it's nicknamed the X-Indy. The X-Indy is an aircraft carrier that was mothballed in Sinclair Inlet, which is part of our traditional exclusive Suquamish territory on the shore of Bremerton. The scraping took place in early 2017 and resulted in the dumping of an estimated 730 cubic yards of toxic waste in the ancestral waters of the Suquamish Tribe. Our name derives from the place of the Suquab, the place of clear salt water. We are the people of the clear salt water, and that's just over the hill here at Old Man House, where Chief Seattle's home was. The water there is very swift and clear, and so we try to live up to our name by trying to keep that condition throughout the Sound. I mentioned the Treaty of Point Elliott and the usual and custom fishing areas of the Suquamish Tribe, and our commitment to protecting treaty reserved rights and resources. And protecting the water of the Puget Sound is essential who we are. Before announcing the settlement terms, here's some background on how we got here. The lawsuit was not our first choice. Before going to court, representatives of the Suquamish Tribe sat down with U.S. Navy officials for a government-to-government meeting on October 28, 2016. We raised our concerns about the risks of the toxic discharges and sediment and water column in Sinclair Inlet. We noted that the deposits could be at least 730 cubic yards or 73 dump truck loads. We asked the Navy contain and properly dispose of the contaminated waste rather than discharging them directly into Sinclair Inlet. On January 5th, 2017, we sent a detailed letter requesting that the scraping of toxic paint containing zinc and copper not take place in the open waters. Literally, the day after that letter was sent, the Navy informed us that the divers were already in the water, beginning to take the toxic paint off the hull of the aircraft carrier. We had exhausted other options. In 2017, we joined with the Puget Soundkeeper and the Washington Environmental Council to file a lawsuit in federal district court. The lawsuit alleged that the Navy violated the Clean Water Act after it scraped the hull of the ex-Indy in the waters of Sinclair Inlet without a federal permit, and that allowed the uncontrolled discharge of toxic anti-fouling paint to the waters and sediment of Sinclair Inlet. In 2019, Washington Attorney General Bob Ferguson joined us in this lawsuit, alleging other claims that his office will address. The key elements of the settlement are the Navy has agreed to a 10-year moratorium on any further scraping of mothballed aircraft carriers in the waters of Puget Sound. That moratorium includes the 6 inactive ships currently in Puget Sound and any additional inactive ships that might be brought into our waters in the next 10 years. During the moratorium, any scraping of aircraft carriers must take place in dry docks where waste can be contained and safely disposed of. The Navy has agreed to place a thin layer of clean sand over 8 acres on the bottom of Sinclair Inlet in order to contain the scraping debris already there from the ex-Independence. This should promote the natural recovery of the area and lessen the further contamination of the waters from toxic hull waste. The Navy will research technologies that allow cleaning to take place in ways that safeguard the health of marine ecosystems. The Navy has agreed to keep all of us appraised of the status of their research. In summary, the ancestral waters and the marine habitat of Sinclair Inlet are vital and natural and cultural resources that have been central to the ways of life of Suquamish people since time immemorial. We have a long-standing government-to-government relationship with the Navy that I've been involved in for well over 15 years due to our overlapping territory and mission within Puget Sound. Over the years, the tribe and the Navy worked to balance our different interests while respecting our legal rights and the jobs that we were all intended to do on behalf of our people. The tribe acknowledges the Navy's efforts to engage in transparent government-to-government relations. By sitting down with our lawyers and technical specialists and our partners in the lawsuit, we were able to hammer out a deal, and that is good for the tribe and for all the people of this region, and it's good for the fragile marine ecosystem in Sinclair Inlet and Puget Sound. We look forward to continuing to work together to assure the recovery and health of Puget Sound. So thank you for the opportunity to make this statement and give you some of the details of our settlement, and thanks to Melody Allen here, who worked really hard on that on behalf of the Suquamish Tribe with the other parties, and I appreciate your attention. Sorry.
Thank you, Leonard. Next, we're going to hear from Bill Sherman, who is standing in for Bob Ferguson. He's the Counsel for the State Environmental Protection Unit Chief, and he's up next.
Thank you very much, and thank you very much, Chairman Forsman. Thank you to the Suquamish Tribe for hosting us here today and for your leadership on this issue. So my name is Bill Sherman. I'm Chief of the Council for Environmental Protection Unit of the Washington State Attorney General's Office. I am standing in today for Attorney General Bob Ferguson, who has come down with the flu. As the Chairman said, he very much wanted to be here today, but the flu is one thing that none of us want to share. I am proud to stand here, though, to share this podium and this table with fierce environmental advocates, including the Suquamish Tribe, Puget Soundkeeper Alliance, and the Washington Environmental Council. Thank you for all of your tireless leadership as stewards of Puget Sound. I also want to acknowledge the presence of two attorneys in our office who served as the lead attorneys on this unit. Assistant Attorneys General Kelly Wood and Aurora Yankee are here. Like I said, they were the lead attorneys for the state in this entire process and will be available to answer any questions on the details of this matter and of the resolution. I also want to acknowledge officials here from the State Department of Ecology who provided tremendous assistance through this process. John Everett and his colleagues are here, and thank you very much. Today's resolution is a victory for the state of Washington and for the marine life that calls Puget Sound home, including iconic species like salmon and orcas. This settlement today sends a clear message that no one is above the laws that protect our waters, not even the federal government. So I'm going to spend a moment talking about the details of the case, including our role as the state of Washington and the additional legal claims that we brought. I'll spend a moment talking about the details of the resolution and then turn it over to our co-plaintiffs in this case. In 2017, the Navy blasted more than 2 decades worth of marine buildup off of the hull of a massive 60,000-ton decommissioned aircraft carrier known as the ex-USS Independence. That released approximately 73 dump truckloads of solid organic material into Puget Sound. That also released a significant amount of toxic metals, including copper and zinc, from the ship's anti-fouling paint. We're here today because you're not allowed to do that, simply put, under state or federal law. The Navy's own sediment sampling found that the level of pollutants that it released while cleaning the ex-Independence far exceeds standards allowed by Washington State. And those toxics harm marine life up and down the food chain, and you'll hear a bit more about that in a few minutes. But in brief, for example, copper can harm salmon's ability to navigate spawning streams or to avoid predators. Our office, the Washington State Attorney General's office, has unique authority and a responsibility to take action to protect the people of Washington and our shared environment. Our partner standing here today brought this case in June 2017. When our office joined this case in March 2019, we brought additional claims that the Navy violated the Washington State Water Pollution Control Act, which sets forth claims that only the state of Washington can bring. That law bars any entity, including the federal government, including the Navy, from polluting state waters. This extra responsibility and enforcement authority gives our office an additional tool to bring to the courtroom and to the negotiation table to fight for the people of Washington State and our natural resources. Under today's resolution, the Navy is required to rehabilitate habitat harmed from the scraping of the ex-Independence by placing a layer of clean sediment on the impacted portions of Sinclair Inlet. In addition, this resolution today gives us the legal authority to seek reimbursement for Washington State and the other plaintiffs for the costs and fees of bringing this suit. But most importantly, as Chairman Forsman said, this consent decree will stop the scraping of ships in Puget Sound or any of our state waters for the next 10 years. So if the Navy needs to clean an inactive ship during those 10 years, it has to do it in a dry dock out of the water to prevent release of contaminants to Puget Sound. The Attorney General is often asked about our office's lawsuits against the federal government. Of the 54 lawsuits that our office has filed against the Trump administration, more than half of them involve the environment, from maintaining critical vehicle emission standards to protecting the Endangered Species Act. As the Attorney General would say if he were here today, our office has prevailed in 25 of those cases. And as he likes to note, we have not lost one yet. 17 of those 25 cases are complete, are settled, resolved beyond any potential appeals. But this is the first settlement we've reached with the federal government that includes injunctive terms that go beyond merely paying standard attorney's costs and fees. And so we want to make sure that in this case we take a moment to acknowledge that the Navy does deserve credit, as Chairman Forsman pointed out, for sitting down with us in good faith to negotiate a resolution. They took these claims seriously, and although we would have preferred not to have to file this lawsuit at all, once we did, they worked hard with us to come up with a resolution that we can all move forward on. Everyone has a duty to protect our shared environment, and we have proven that in court over and over again. Keeping Puget Sound clean is vital to Washingtonians' health and the survival of our environment. I now want to hand it over to Caitlin Kinn, staff attorney for the Puget Soundkeeper Alliance, and Mindy Roberts, the Puget Sound Program Director for the Washington Environmental Council. Thank you very much.
All right. Well done.
Hello. I want to start by thanking Chairman Forsman and the tribe for hosting us and for partnering with us and Washington Environmental Council and the state of Washington on this case. It's great to be here today to share some good news with everyone. When the Navy scraped the hull of the 1,000-foot inactive aircraft carrier, the ex-USS Indy, in 2017 in Sinclair Inlet in the water without first obtaining the legally required federal permit, Puget Soundkeeper and our members and supporters were shocked and very disappointed. The Navy did it despite first having encountered substantial concerns voiced by the Suquamish Tribe and by the Washington Department of Ecology and by the US EPA. One of Puget Soundkeeper's key focuses is enforcing clean water laws when it's necessary to protect Puget Sound and the communities that rely on Puget Sound. We're glad today to stand with the tribe, with the state, and with Washington Environmental Council to share with the public and the communities that we represent such a positive resolution to this lawsuit. First, I want to speak briefly to the specific legal claim that this activity required a permit and why that actually matters. So Section 301 of the Federal Clean Water Act makes it illegal to discharge pollutants from a point source without first obtaining a Section 402 permit. It's called a National Pollution Discharge Elimination System, or NPDES permit. So here, the hull and the equipment that was used to scrape it are point sources. And the release of the estimated 73 dump trucks of waste into Sinclair Inlet most certainly qualifies as pollutants. These waterways belong to the public, and no entity has the right to pollute them, even when that might be the easier or less expensive option. NPDES permits are used all around the country successfully to control pollution discharges. And these permits are important because they require monitoring to track exactly what is being released into the environment, and they require specific actions and controls to minimize the harm. We at Puget Soundkeeper see facilities of all sizes all around Puget Sound successfully employing these measures, including small businesses, every day. And without having permits like this in place, the public is denied a full understanding of what was dumped into their waterway, and they're denied the opportunity to minimize that harm. The Navy's decision to dump the pollution into Sinclair Inlet without the permit was particularly egregious because of the waterway's already impaired status and the vital need to focus now on recovery. The in-water area around where the scraping occurred in Sinclair Inlet has suffered the effects of pollution from generators, mainly the Navy, for many decades. A past marked by clear disregard for the waterway's health has landed Sinclair Inlet on the Clean Water Act Section 303D list of impaired waters, which means that monitoring shows that the waterway suffers from such high pollutant levels that we know them to be unhealthy for marine life and people. In 1990, after a century of contamination by the Navy, the waterway began the process of being listed as a federal Superfund site, meaning that it was so highly contaminated that it was designated as a national priority for cleanup. Since that time, the site's Superfund categorization has resulted in the expenditure of significant public funds and tribal funds to restore and remediate the contamination and pursue recovery. As of today, the site is still listed as a national priority, and the process is not yet finished. Data show that the sediment is still contaminated with copper, confirming that more work needs to be done if we are to fully mitigate the problem. It is unacceptable anytime a new pollution source jeopardizes progress that has already been made and risks turning back the clock in this way. Pollution cleanup actions like this only succeed when the pollution faucet is turned off. Today's settlement marks one way in which we are demanding that that faucet is tightened. At the end of the day, stopping the Navy from doing what they did is just plain common sense, and we trust that Washingtonians agree. Boaters and vessel owners around this region would never have been allowed to do what the Navy did here. Owners and operators of vessels much, much smaller than this managed to follow legal requirements prohibiting this type of dangerous pollution dumping. In a better day, we hope to expect that we can rely on our federal government to set an example at the outset of how things should be done to improve the status quo and create a better, more sustainable future. But in the meantime, at the very least, we can and we must expect that our government does at least the bare minimum. Today's settlement holds the Navy to task for their poor decision and provides relief to prevent future harm. We're glad to move forward, and we promise that we will continue to hold the Navy accountable when they pollute Puget Sound. And I'd like to wrap up by thanking our attorneys at Smith & Lowney in Seattle, particularly Meredith Crafton and Richard Smith, for representing us in this action. Thanks.
Thank you very much. That was Caitlin Kinn from the Puget Soundkeepers, the Puget Soundkeeper Clean Water Attorney. Thank you. And next we have up Mindy Roberts, who's the Puget Sound Director for Washington Environmental Council.
Good afternoon. My name is Mindy Roberts, and I lead the Puget Sound program at Washington Environmental Council. For over 50 years, we have fought for clean air, clean water, and clean energy for all. And WEC only litigates when we see it as an essential tool for protecting the environment and communities. And this was such an egregious violation that we felt compelled to stand with our partners at the Suquamish Tribe and Puget Soundkeeper to hold the Navy accountable for their actions and ensure that this does not happen again in Puget Sound. We're very grateful that the state of Washington intervened, and thank you to Chairman Forsman and the Suquamish Tribe on whose land we stand. I would like to provide a little bit of context on why scraping the hull of a former aircraft carrier with no permit and no pollution controls was a problem. Prior to joining WEC, I spent 16 years as an environmental engineer at the Department of Ecology, where I designed monitoring programs and developed computer models of how toxic chemicals and other pollution gets into Puget Sound and the harm that pollution causes. And my position included reviewing and approving the Navy's work in Sinclair Inlet in the 2000s. My interest was piqued on this issue when I saw a Navy document that described the hull scraping as gently brushing barnacles from a hull over 1,000 feet long. Now, I am not a boat owner myself, but I'm fairly certain that a fairly casual pass, a light touch, certainly was not enough to dislodge barnacles encrusted on a hull. I also realized that anti-fouling paint, which is applied to boat hulls to reduce marine growth, contains high concentrations of toxic chemicals. That's how anti-fouling paints work. And these paints contain copper and zinc at high enough concentrations that they're toxic to marine life. So when the Navy proposed scraping the hull vigorously enough to remove barnacles, I knew that they would also be releasing significant quantities of copper into Sinclair Inlet and Puget Sound from the anti-fouling hull paint. Now, copper is a toxic chemical, and it's far more toxic to marine life than it is to people. And salmon that are exposed to very low concentrations of copper, it affects their sense of smell. They lose their ability to navigate, which is clearly a problem. And the Navy in their own documents noted that chum, coho, and Chinook salmon could be present within the Puget Sound Naval Shipyard during the time of in-water cleaning. So they knew salmon could be exposed to high concentrations of copper from the scraping, and concentrations that are thousands of times higher than levels that are dangerous. So unfortunately, Sinclair Inlet is already a Superfund site, and it has some of the highest concentrations of copper in the entire Puget Sound region. And in fact, the Navy themselves have studied copper in Sinclair Inlet going back nearly 20 years. And they knew that copper leached from anti-fouling paints from boats was the source of nearly 2/3 of the ongoing copper discharged to Sinclair Inlet, even more than from contaminated stormwater from nearby developed areas and more than the ongoing discharge from the Navy's dry dock facilities. The shipyard itself is Puget Sound's 9th overall largest source of copper in the entire region. So that's why WEC joined our partners to initiate this litigation. The Navy is the largest source of copper pollution to one of the most contaminated sites within the Puget Sound region, and they added to the pollution by using a practice in water hole scraping that is forbidden for any other recreational or commercial boat. And while we appreciate that the Navy was concerned about the potential spread of invasive species to Texas, we knew they could do better to help endangered species here in Puget Sound and the people that depend on salmon. Protecting and restoring Puget Sound will take everyone doing their part, and we all have more work to do. And that includes personal choices that each of us make in reducing toxic pollution from our everyday activities. That includes how we get to school and work, the products that we choose to use in our homes and our businesses. All of these activities and products, they release toxic chemicals that we cannot see with our own eyes, but that still cause harm to others. But that also means the Navy needs to be a better leader in its choices, both here at the Naval Base Kitsap and throughout their operations around Puget Sound. Marine waters are the lifeblood of our region, and we need to work together on solutions. We see some real opportunities for the Navy to step up here, and the settlement agreement is a great first move. We don't want to see in-water hole scraping in the future, and particularly when there's a dry dock facility adjacent to these sites where the holes could be scraped in a contained environment, keeping pollution out of Sinclair Inlet and Puget Sound. Washington Environmental Council looks forward to working with the Navy in the future to reduce its impacts on Puget Sound and to be a better neighbor. As my colleague Caitlin once noted, pollution is not patriotic. The Navy can and must do better. Thank you.
Thank you very much. So we're going to take questions in a moment from reporters who have dialed in on the phone, but I want to give people here first chance to ask any questions. Yeah.
How soon could some of this work start being done in terms of adding this sediment there in the inlet? And also when you talk about covering the cost and fees of bringing this suit, as well as all the other work they're promising to do, what is the value of this settlement?
Do I need to repeat the question for the folks on the phone? So this is Bill Sherman from the Attorney General's office. The question was, when does the remediation work begin, or when does the rehabilitation work begin on the site, and what exactly is involved in the attorney's fees and costs that I mentioned? The consent decree requires the placement of the sediment to begin in 2021. This is something that takes some study. And so that'll begin then. The fees and costs is something that we expect to sit down to negotiate with the Navy. Hopefully, we'll be able to come to an agreement. If not, we'll be going to court to ask for a specific number on that. Honestly, we haven't done all of our calculations yet. We've just filed this consent decree today, so I don't have a good number for you on that yet.
Did you guys discover why they decided not to use the dry dock, and what would keep them from doing this again?
This is Mindy Roberts from Washington Environmental Council. We asked that question ourselves early on. The question is, why didn't the Navy use the dry dock facilities there for this particular action? And that puzzled us for quite a while. The Navy has, this is one of very few shipyards on the West Coast that is capable of doing this work, and they had a backlog of ships that they were processing through there. However, we found it a little hard to believe that in the 16, 17 years that this particular floating craft sat in Sinclair Inlet, that there had not been a break. But that was the explanation that the Navy gave to us, is that they were prioritizing their active ship fleet. However, we do think that there's some opportunities to make sure that this is worked into their schedule moving forward, so they should be able to schedule around it.
Other questions?
Yes, is this going to affect your other lawsuit that you have going on right now involving sewage?
I'll try to take that one. I assume that's the sewage spill. Melody, is that the one that we're researching? No, they're separate actions, and we're just trying to hold the Navy accountable as being, important part of our economy here and a tenant on the Sinclair Inlet since 1891. Of course, we've been here a lot longer. And some of that's investment based because they have an antiquated system there, and I know that the previous Captain Schrader was really engaged in trying to get those investments necessary to improve an old facility. So on some levels, I think that the Congress needs to invest better in their infrastructure needs. And there's a lot of needs that they have, and it doesn't help that the Trump administration is taking money away from the Navy to build, structures on the U.S.-Mexico border that were allocated by Congress because the Navy, has a lot of needs, and that doesn't help matters any when there's money being taken away from them. So we look forward to Congress, putting that investment in. There is a lot of work coming to the Puget Sound Naval Shipyard. Congressman Kilmer has informed us that there's billions of dollars of work coming in, and we are looking forward to the Navy consulting with us on those projects, of course, and their impacts. And hopefully it will see some of that money used to invest in protecting the Sound from future spills, and also allowing for the dry docks to have the space necessary to not only service their fleet of aircraft carriers that are active, but also to dispose of those that they have in dry dock. I just want to mention that Robin Sago, our treasurer for Tribal Council, is here. If you have any questions, she can help out as well later on. And just to know that this tribe and the Navy have had a long relationship, and we try to work together on a lot of things, and they've helped us in cultural events like our canoe journey, and we have a active government-to-government relationship, and it's just one where we have to hold them accountable for our first priority, which is protecting our treaty resources.
Can I correct something that I said a minute ago? Sure. Yeah. So this is Bill Sherman from the Attorney General's office. I misspoke when I answered your question about the placement of the layer underneath the site. We expect it to begin in 2021. The consent decree requires it to be complete by the end of 2022. So I apologize for that.
Okay, any other questions?
Yeah. Just curious from the panel's perspective on the fact that our Navy, one of its primary missions here in the Pacific Northwest is the recycling of not only our nuclear-powered submarines, but perhaps to come the Nimitz-class aircraft carriers and the Forrestal ones like we saw with the USS Independence. Is there an inherent, sort of conflict here that's going to continue with the fact that we've basically, I'll just put it in layman's terms, have a whole bunch of old rotting ocean ships that will be sitting in Sinclair Inlet for the foreseeable future, next century even?
I can try to answer that. I think that that's one of the missions of the shipyard, of course, is disposal of these vessels. And I'm not an expert on the decisions, and sometimes we get puzzled by the decisions that are made to where ships are decommissioned and where they're torn up, and et cetera, et cetera. I'm not an expert on that, but I think that that's one of they have multiple missions, but those seem to be one of the primary missions has been for years is disposal, but they also do a lot of maintenance. So it's a very strategically based and in-demand facility. And as you know, you probably the Navy was here; they could tell you the details of the number of dry docks, which are limited, that they have on the West Coast. And so there is a high demand for that. Of course, that, like was said earlier, that was one of the reasons they said they had to do it in water, was they didn't have the space for it. But I think that it can be done, hopefully with a minimal amount of impact, but we'll be monitoring that in the future.
This is Bill Sherman from the AG's office. Just to underscore that, we are grateful for the work that the men and women of the Navy do in our region, and we are mindful of the mission to protect the United States of America. We believe that that mission also involves protecting our environment and our marine life, and we are confident that the ingenuity and the commitment to principle and the commitment to the law that the Navy embodies allows them to comply with environmental law and all of our collective responsibility as stewards of this resource. The Navy has every ability to follow the law and complete their mission in Puget Sound. We support their ability and their capacity to do that, but the laws are also there for a reason. And like any of us, if they messed up, the law's there to remind them of their obligations, and we'll be there to make sure that we can enforce it.
Okay, let's turn to the phone, and then we'll come back one more time in case there's any last questions here. Who is operating our phone? Okay, so on the phone, are there any questions there for the panel? Is that operational?
Yes.
Okay. All right, I'm not hearing any. It's not on mute. Okay, so one last, go ahead.
There's availability for one-on-ones after this.
Yes. Okay, any last questions? Thank you very much for coming, and there are copies of the statement over there for you. There's also a Dropbox where we've placed some diagrams, some photographs that you're free to use in any of your media, and also the press release. And please do let us know if there's any other ways we can help you.